Okay, so thank you, or good evening, everyone, and thank you for joining me today. My name is Carla Smart, and I'm here with Charlotte McDonald from Stone King. Hi, Charlotte, how are you doing?
Hello, Carla. Good to be here. Thank you.
So the topic of today's webinar is navigating cross-border estate and succession planning for British nationals. I would like to start the webinar today by giving just a very brief introduction to myself. So I am a chartered financial planner and Skybound Group's head of pensions. Over the last 15 years or so, I've had the privilege of helping expatriates with various aspects of their financial planning. Over the last 10 years, I have been working in Switzerland. But prior to that, I was fortunate to have spent some time living and working in various places across Europe. So having left the UK back in 2008, I very much understand from both a personal and a professional level some of the challenges that people face when living abroad and dealing with cross-border issues. So I work for a company called Skybound Wealth Management, and for those that are not familiar with Skybound, we actually began as a UK-based financial planning organisation over 25 years ago now. We quickly expanded our operations into Switzerland, the Middle East, the USA, and then we were acquired by Skybound Capital Group in 2020. And since this acquisition, we have been going through a period of expansion and growth, effectively strengthening our existing client proposition. So we now have over 10,000 clients across the globe, over $1 billion of assets under management. We've got 200 staff members, and you can see from this map where we are situated across the globe, and we have plans to continue to expand, as you can see here as well. We are fully licensed and regulated in the jurisdictions in which we operate. And yes, I'm pleased to share that now, in addition to the ARIF license that we already held, we obtained the FINMA license this year, which has enabled us to essentially expand our offerings in the Swiss market. In terms of what we actually do as a company, so we are financial planners, essentially. So we help our clients with various aspects of their finances, whether that be planning for their children's education, for their retirement, estate planning. Our parent group, Skybound Capital, they work more so in the wider financial services sector. And it's been really interesting over the last few years just to learn about some of the other areas of the business and look at ways in which we can actually work together to bring further solutions to our clients. So Charlotte, if I could pass over to you now, perhaps you could introduce yourself and Stone King.
So who am I? As Carla said, my name is Charlotte MacDonald, and I'm an English qualified solicitor, and I've been working with Stone King since 2013, so just over 10 years. And my area of specialism is international and cross-border succession. It's an area of work that I'm really interested in and really quite passionate about. All my clients have an international element to them and a connection to the UK. So they could be British and they've moved to Switzerland or France or Portugal or the US, somewhere else in the world, or they may be from somewhere else and moving to the UK either on a temporary or permanent basis. I have three main types of clients: individual people like you and me wanting to get succession or tax advice. I also advise other firms of solicitors who instruct me to act on their behalf when they encounter an international element of work that they're not familiar with. And finally, I also act for a number of large charities and schools as and when they receive overseas bequests or gifts. I'm also quite an international person myself. I have lived over the last sort of 15, 20 years in Australia, Canada, France, and I'm now back based in the UK for most of the year.
Thank you, Charlotte.
So who are Stone King? Stone King are a national law firm based in England. We have 6 offices, Bath, Birmingham, Cambridge, Leeds, London and Manchester. We are quite an old firm. We can track our history back to 1785. We are a full service law firm, but we do have sectors in which we specialise, especially charity, education and private client work, with a team specialising just on the international side of things. The international and cross-border team focuses on advising on cross-border estate administration, successions, will planning, and tax advice, especially inheritance and capital gains tax advice when gifting, domicile advice, and legal opinions for overseas lawyers, amongst other things.
Great, thanks, Charlotte. So I'll just run through the agenda for today. So first of all, I will be talking about the importance and why we should be thinking about estate planning, and when we do want to put a plan together, where we should begin. Decumulation. So once you have built up your assets and want to start drawing down from your assets, where should which assets should you begin to draw down from first? I'll be discussing and highlighting the importance of nominating beneficiaries on your pension plans. I'll be asking Charlotte why we should be writing a will. Charlotte will be talking about some of the differences between civil law and common law and touching on matrimonial regimes which exist in certain jurisdictions. We'll also be looking at forced heirship and when you may want to be considering using the European succession law. We'll be looking at some of the differences between domicile and residency and touching on some of the recent changes that were introduced in the recent spring budget from the government. And finally, we'll be looking at gifting, when you may want to consider doing it and what things that you should be thinking about if you do want to start gifting. Okay, so why plan? So first of all, it's to protect your beneficiaries. So in the event of your death, it's to ensure that your assets, your estate is passed on to the people that you want it to go to. Secondly, it's there to protect your dependents. So you may have a young family, you may have a dependent spouse. Without having a clear plan in place, adequate provision may not actually be available for your loved ones at a time when they need it the most. Avoiding family disputes. And this often happens, particularly when there may be a sudden death in the family. You may see it may cause family disputes when it comes to distributing the estate. And I would say here that communication here is key. Having something written by means of a will, so that is clearly in place, it can avoid family arguments in the future. Minimizing tax. So we'll come on to learn throughout this presentation that different jurisdictions have different rules with regards to succession and tax. Understanding what these rules are in your country of residence or where you potentially plan to be resident in the future is really important, because there may be certain vehicles and structures that can be put in place in order to ensure that you are minimizing the tax that your loved ones may then have to pay in the future, and you are therefore preserving your assets for the benefit of yes, your beneficiaries. A legacy. So a number of my clients speak to me about wanting to be able to leave a legacy for their family. And understanding what that may look like is really, really important, because obviously if you have a portion of your asset which is earmarked for inheritance, then this will naturally have an impact on what is then available for expenditure during your lifetime. And finally, peace of mind. So having a robust and sound plan in place will help you sleep at night, knowing that in the event of your death, then your loved ones are fully protected. So you want to make a plan, where should you start? So first of all, it's thinking about your current residency or where you plan to be resident in the future. Do you really understand, in the event of your death, first of all, who your assets will go to, and secondly, what the tax implications will be? Understanding what you have is important. So create an inventory, write a list down of the assets that you have, and in that list, specify what type of asset it is. Is it cash in the bank, investments, pensions, property? It's also important to distinguish in terms of where these assets are based, the jurisdiction in which they're based. What expenses do you have right now, and what will your expenses look like in the future? What are your family's needs going to be now and in the future? Perhaps you want to help your children get on the property ladder. Perhaps you want to make funds available to help your grandchildren and their education in the future as well. All of this needs to be built into that plan. Reviewing, so knowing who your beneficiaries are and reviewing these on a regular basis is also extremely important. So decumulation, so once you've actually built all your assets, you've put it all together, let's say you've now got to retirement and you want to start drawing down from these assets. You have investments, pensions, property, and so on, but you're not sure which assets that you should be taking from first. So it's important to consider how each of these individual assets are treated, not just from an income tax perspective, but also from an inheritance tax perspective, in order to determine what you should be taking from first. For example, in the UK pension is outside of your estate for inheritance tax purposes. So for some people, it then therefore may make sense to start drawing down from other assets before their UK pension. However, in other jurisdictions, the UK pension may form part of your estate for inheritance tax purposes, so it may not be as efficient to be leaving that, and it may make sense in another jurisdiction to actually utilize that first. So it's really important, obviously, to distinguish between the types of assets and to consider how they would be treated where you are or where you plan to be in the future. The importance of nominating beneficiaries. So I would urge anyone that has a pension to ensure that they have nominated beneficiaries, and two, that these beneficiaries are up to date. It really helps guide the scheme, the trustees, to know who they should pay the benefits to. And if they know who they need to pay the benefits to, then it also means that the benefits can be paid out much more quickly. Secondly, it will ensure that the beneficiaries have access to all of the death benefit options. If there are no beneficiaries listed on the policy, then there may be restrictions in terms of how the beneficiaries can actually take the benefits. And the drawdown income will not be tested against the new lump sum death benefit allowance. Therefore, it's important that the beneficiary has the option to select the drawdown option. Okay. So why write a will? So Charlotte, if I could bring you back in here, of the many areas that you help your clients with, I know that your firm does assist in writing wills. So if you could please talk about why people should be thinking about writing a will, and perhaps also touch on when this should be reviewed and looked at in the future.
Yeah, absolutely. Happy to help.
Okay, right.
Okay.
Over to you.
Okay, so perfect. So why write a will in the first place? So if you write a will, you have control over what's going to happen after you die to your assets. If you don't write a will, you are limited to the succession rules in place at the time. So as I'm sure most of us will know, a will is a legal document that sets out how you want your estate to be handled in the event of your death. The will can contain an awful lot of information if required. It can allow you to appoint guardians for your children. It's important to note that these guardian provisions can be variable in different countries. So it's important to note if you have it in your will, that will definitely work in England and Wales, but we would need to double check if it's going to work if you end up moving to a new country with your children. You can make provisions for your loved ones within your will, so you can set out clearly who you would like to inherit and what assets you would like them to inherit. Again, this can be subject to local rules, which we'll talk about a bit later on in the presentation today. And you can protect your assets in certain ways. So in many countries, you can set up trusts in which to place your assets on your death to protect them if you're worried about a family member perhaps spending those assets in a certain way, or if you're worried about protecting their benefit, for example. Your will can also help to minimize tax. There are a number of structures that you can place in your will, depending on your circumstances, that can take advantage of inheritance tax allowances in different countries, depending again where your assets are, to ensure that you are maximizing the tax efficiency of your will. Right, when to update your will. This is an important one. So you don't obviously need to update your will every year. That would clearly be not a good use of your time or money. But there are certain life events when it's a good idea to have a look at your will. So if you have children or have additional children, a good idea to check the will to make sure it's up to date and is reflecting your current circumstances. If you marry or divorce, essential to update your will when you marry. If you enter into a civil partnership or marry, then that will automatically revoke your previous will under English and Welsh law. So that can really change things. Do make sure you double check your will when you get married or enter into a civil partnership in the UK or abroad. Also have a look at your will when you divorce, if you divorce. Although the will is still likely to be valid, there are terms within it which may no longer work. So, for example, your spouse will be treated as having died before you, which you may not want to leave them anything, having divorced them, but you may still want to look after them going forward. So do check it then. If an executor or a beneficiary dies, again, good time to check your will. You may have drafted replacement or backup executors or beneficiaries within the terms of the will, but it's sensible to check. And finally, if you move to a new country, really good time to look at your will. Your current estate planning may be very specific to the country in which you used to live, and it may not work so well moving forward. So a brilliant time to check your will if you move to a new country.
Okay, thank you, Charlotte. And I mean, from a planning point of view, the legal system that a country essentially follows can often determine the most appropriate structures and vehicles that are in place. I mean, as Brits, we are familiar with trusts that can be effective tools for obviously inheritance tax purposes. However, obviously, from jurisdiction to jurisdiction, trusts don't necessarily work everywhere. So if you could please just explain some of the differences between civil law, common law, typical countries where these may be found, that would be really helpful. Thanks.
Yeah, no problem at all. So let's start with civil law. Civil law is probably the most common, not a good word to use here, confusing, probably the most usual type of law found across the country. Found across the world. Most of Europe, China, Japan, a lot of Africa, all of South America are all a civil law jurisdictions. They're all based on civil law. For succession purposes, civil law countries usually state who you have to leave your assets to on death. You usually don't have the freedom to leave your assets to whomever you like when you die. These countries also usually don't recognize trusts. They almost certainly won't have trusts within their legal structure, and they may only have limited recognition of overseas trusts.
Okay.
By contrast, common law, this is what British people will be most closely associate with. Common law covers the UK, the US, Australia, Canada, a lot of the Commonwealth. And under common law succession principles, you can leave your assets to whomever you like when you die, broadly speaking, whether that be friends, family, even the cat's home. It really doesn't matter. Common law allows the use of trusts. And as Carla's mentioned, trusts can be a really good vehicle to protect wealth, either for beneficiaries, and they can also be useful for tax planning in some circumstances. And yeah, I've just mentioned testamentary freedom. Yeah, so
Yeah.
that's leaving your assets to whomever you like when you die. Finally, we've got religious and hybrid systems, such as India and the Middle East, North Africa, all have these. And how you can leave your assets in these countries is often based on your religion. So India, for example, you have different ways in which you can leave your assets, dependent upon whether you're Christian, Muslim, or Hindu. So it's really important to understand how religion can make a difference in some countries.
Okay, thank you. That's really interesting. And yes, in terms of matrimonial property regimes, I know in certain places that this exists. So perhaps if you could please touch on the places that you have come across matrimonial property regimes, and talk about some of the different types of regimes and how they may impact estate from an estate planning point of view.
Yeah, absolutely. So matrimonial property regimes, other than being quite a mouthful to say, it's very important to understand them in terms of your estate planning. You should know early on when estate planning whether you have a matrimonial property regime, because if you do have one, the terms of your will may not be followed. So I've listed a few of the most common types of matrimonial property regime. The first one is a separation of property, community of acquired assets. So this is the default option if you get married in France. The assets that you own prior to your marriage are still yours, and your spouses are still theirs. But from the date you're married going forward, your assets are deemed to be owned jointly, regardless of in whose name they're held. The second most common one that we come across is a separation of property regime, where nothing is owned jointly, and what is yours, what is your spouse's is your spouse's. The separation of property regime can be altered on divorce. So in the UK, for example, although we consider what is mine, what is my spouse's is my spouse's, on divorce, we lump it all together before it's split up. And finally, we've got a universal community of assets regime, and that's broadly speaking where all assets are owned jointly, whether they've been acquired before the marriage or after the marriage. These universal community of asset regimes sometimes have clauses within them that say on the death of the first spouse, the surviving spouse automatically becomes the sole owner of all the assets. It can be very straightforward. However, if the first spouse to die has written a will, and in that will they say, I would like all my assets to go to, my nephew John, then unfortunately, John isn't going to receive a penny. And that's because the matrimonial property regime is applied before the will is looked at. So in that case, everything would pass to the spouse, the surviving spouse. So the terms of the will can't be followed. So do check if you've got a matrimonial property regime, because it can really change the outcome of your estate planning.
Yeah, that's really an important point, to check that they're not contradicting one another and actually working together, or else it could cause quite a lot of confusion on death. I'm sure that must have happened a lot of the time in the past.
Yeah, unfortunately, yes.
And obviously, this is something. Matrimonial property regimes. We have them in France. Have you come across them in other places as well?
Yeah, so they're common in a lot of civil law jurisdictions, but they can also be found in some common law jurisdictions. So in the US, for example, some states such as California have community property. So most common in sort of European civil law countries, but you can find them elsewhere as well.
So it's like the equivalent of a prenup, really, isn't it?
Yes, yeah, in some ways quite similar.
Yeah. Okay. Good. So Yes, I mean, in the UK, as you've already touched on, we are free to leave our assets to whoever we choose, whoever we'd like to. But as you've already talked about, in certain other jurisdictions, that's not the case. So perhaps if you could please just explain what forced heirship is, and also touch on why some of the attendees might want to consider actually using the European succession law, which came in a few years ago.
Yeah, absolutely. So forced heirship essentially means that you have to leave your assets in a certain way when you die. For a lot of us Brits, we find that quite a difficult concept to understand. You know, we should be free to leave our assets how we want. But from a sort of more European mindset, they find it terribly immoral that we can cut out our children from our wills. So it's two very different mindsets.
Mhm.
Under forced heirship, in nearly all cases, in fact, in all cases that I've come across, the children are protected. So you have to leave your assets to your children. The percentage varies depending on the country and how many children you have. And sometimes there are also protections for spouses and registered partners. As Carla has just brought up there, found in most European countries.
Mhm.
And because of this, the European Succession Regulation, also known as Brussels 4, came into force back in 2015 with the idea of harmonizing successions throughout Europe. So if you have a sort of very international individual who owns assets in 5 different countries in Europe, the idea of this regulation was that the law of their habitual residence would govern the succession of all those countries. So you're not trying to put 5 different forced heirship regimes over the assets, you're just looking at one. All good. However, it also gave people the possibility of the option to make an election of national law. So if you are French and you're living in Germany, but you would like French law to apply to your assets, you can write a will and you can say, I would like French law to apply on my death. Very useful.
Mhm.
Um, it's also very helpful for British people. We can elect for British law to apply. There is actually no such thing as British law. Confusingly, we have English and Welsh law, Scottish law, Northern Irish law, but we can, in this context, say British law, and I'm most closely associated with England, for example. And
Mhm.
by doing this, we can then leave our assets to whoever we like using our testamentary freedom. And so if we want to leave all our assets to our spouse, for example, we can do that.
And I know, obviously, we've had to touch on this before, Charlotte, that the fact that in France there was some regulation that had come in just a couple of years ago now, it was back in 2021, wasn't it? That actually may undermine the regulation, the European succession regulation. So for any French resident attendees, I think it would be quite useful to touch on that just as something to be aware of, really.
Yeah, absolutely. It's an interesting law. It came into force back in 2021, and it applies if you are an EU resident or national, or any of your children, your descendants are EU residents or nationals. And if that is the case, then the notaire dealing with your succession on your death will ask your children if they agree with the terms of your will if French forced heirship hasn't been followed. So this law applies primarily to those without a type of forced heirship in the country. Like British people, we don't have forced heirship.
Mhm.
It won't apply in the same way if there is a type of forced heirship in your country. But for British people living in France, it's important to be aware that your election of British law at the moment may not be watertight.
Okay. And this
It
is just for French assets, yeah.
This is just for your French assets.
Mm.
Although when the notaire calculates um, what they think your children should have, they can look at the worldwide assets. So if you are resident in France and you have made an election of British law to apply, it's a really good time to review that to see if it's still going to work for you and if there's anything you can do with your estate planning where your assets are located to help minimize its effects.
Yeah. But ultimately, if the children actually agree and are happy with the division and don't contest it, then the will can still be followed effectively.
Yeah, that's right. So if you get on very well with the family and you've made a will in which you leave everything to your spouse rather than leaving a percentage to your children, the notaire will ask your children, are you happy with the terms of, dad's will? And if the children say yes, then excellent, the terms of dad's will be followed. So there is still use for the EU succession regulation in France, for sure. And it's also worth commenting that this change to French law is contrary to European law. So we may well see it repealed in the next few years, although it is law for now.
Okay. Well, something to look out for then in the future.
Yes.
And there are just a couple of examples here of forced heirship. So if a married mother dies and her husband would then receive half of the estate under inheritance law, the other half is divided evenly among her children. And if a child has predeceased the mother, then this part of the estate then would go to his or her descendants. And another example here, so if an unmarried father dies, his entire estate would then go to his children. And if he has a partner, she inherits nothing pursuant to the law. So yes, so we've touched on forced heirship. If we can now move on to domicile and residency, and it's something which a number of my clients sometimes struggle with in terms of knowing the differences between them. And just while we're on this subject, I think it would also be worth noting in the spring budget, the government did announce changes to inheritance tax. So yes, Charlotte, if you could please touch on that as well, that would be really helpful.
Absolutely. So we'll start with domicile. So domicile under English law is important for two different things. One, for succession, so who gets what when you die, and two, for tax. So domicile, it doesn't have a nice, easy definition, I'm afraid. It is a mishmash of lots of different things about your life. So you have a domicile of origin, which is usually the place your father considered his real and permanent home to be at the time of your birth, if your parents were married. But you can lose that domicile of origin and acquire a domicile of choice in a new country if you move there with an intention to permanently remain. And when ascertaining domicile, we'll look at many, many different factors to do with your life. We will look at your residence, your location of your family, where you are a national of, where you vote, even where you want to be buried. So it is quite a complex idea. But for many people, if you were born in a particular country and your parents were from there and you still live there, that is the domicile you will have. Now, domicile is different to residency. Residency is much more straightforward from a UK point of view, and this is where you live. Under UK tax law, you are resident if you spend 183 days here. That's the starting point. There are also some more complex rules called the statutory residence test that we can look at. And so in some very extreme examples, you could spend really only a few weeks in the UK to be tax resident. But generally, residency more straightforward to ascertain than domicile.
Okay, perfect. And yes, we had mentioned previously that there had been some changes in the spring budget being introduced. So do you want to maybe touch on that?
Yes, thank you. So the spring budget announced a raft of possible changes to domicile and to inheritance tax, but the one that's relevant here is how the UK will look at domicile for inheritance tax purposes going forward. At the moment, we have this sort of wishy-washy, slightly grey definition of domicile, which can be argued either way.
Sure.
But going forward, for tax purposes, if you have left the UK and a period of time has elapsed, in this case, 10 years, then you will lose your domicile, your tax domicile of the UK for inheritance tax purposes. That's quite different to the current position. As things stand at the moment, you could be out of the UK for 50 years, but if HMRC thinks you still have a really strong connection to the UK, they can still try and assess you for inheritance tax on your death. So the new 10-year rule, as and when it comes in, if it does, will provide a good level of certainty there.
Yeah, it's a bit more clarity than how it had been previously, because it's quite hard when it comes to domicile and the current rules for people to plan, because obviously that can sometimes change depending upon circumstances and life events and so on. So again, something to look out for then.
Yes, so something to check over the upcoming year. Obviously, we may have a new government by the end of the year, so things may change. But at the moment, this is going to come in.
Okay, good. So let's now have a look at a couple of case studies. So the first one, we have Mr. and Mrs. Jones. They were married in the UK and resident in France. They've got 3 children. One child is from Mr. Jones's first marriage. They don't have a will in place. And they've got a family home in France worth €1 million and a property in the UK worth €300,000. Other assets, including a UK pension. And Mr. Jones, he dies intestate, so without a will. So Charlotte, if you could please talk through what that would look like in terms of who gets what and what the tax implications would be with this scenario here.
Yeah. So firstly, we need to decide which succession law applies to which countries. So because the property is in the UK, or they do have a property in the UK, that will pass according to English law. And the real property in France is going to pass in accordance with French law. So we've got 2 very different legal systems applying to 2 different assets here. Now, the French estate, which will pass in accordance with French law, is going to be divided between Mrs. Jones and the children. The reason for this is because French intestacy law allows the surviving spouse to receive 1/4 and the children to receive the other 3/4. There may be some wiggle room for Mrs. Jones. She may be able to agree a slightly different division with the children, and she is likely to have the right to stay in the family home for some time. But broadly speaking, that's what's going to happen in France. Now, in England, it's different. In England, spouses have a much greater right than children do to a certain extent, and a spouse will inherit the first £322,000 as things currently stand. As the UK property is worth less than that, Mrs. Jones will inherit the English property by herself. She won't have to share that with the children.
But that does not include the pension, the UK pension. We're just talking about the UK property.
Correct. Yeah. So, Carla, as you mentioned earlier, the importance of having a letter of wishes, a beneficiary nomination form in place for your pension. Pensions in the UK do not sit within the estate, so they don't pass either under the will or under the intestacy rules. So they are separate. So yeah, we're just looking at the properties.
Yeah, okay. But from a French tax perspective, there may be some considerations there.
Yeah, so French inheritance tax taxes the individual beneficiary rather than the estate as a whole. So some beneficiaries receive larger allowances and pay lower amounts of tax compared to others. Broadly speaking, the more closely you are related to the deceased, the better your tax allowances are and the lower your rate of tax. So spouses receive everything free of tax. So that's very straightforward. That's good for them. And children receive €100,000 tax-free and pay tax on the balance on a sliding scale between 5 and 45%. It's important to mention that stepchildren are treated differently. In this particular case, all the children are Mr. Jones's, so it's fine that they're all entitled each to receive this tax allowance. But if Mr. Jones had a stepchild, then that stepchild would only receive a tiny tax-free allowance of €1,594, and they would pay tax at a flat rate of 60% on the balance. So if you do have stepchildren, it's important to think quite carefully about your estate planning, because even if you would like to treat your children and the stepchildren equally, the tax law doesn't easily allow it.
Okay, good. So I mean, based on this scenario, it might not necessarily, if he's died intestate, without a will, it might not necessarily be in line with what their wishes are. It may not necessarily be ideal for Mrs. Jones to be owning property with the 3 children, for example. If they, obviously the most important thing to establish is what their wishes are and who they want to receive what, and how that can be done in the most tax efficient manner. As you had touched on previously earlier on in the presentation, for couples married in the UK, then the marriage regime that would be considered to be in France would be the separation of property. Given the fact that Mr. Jones has a child from a previous marriage, would it be possible to change their marriage regime to the universal, if he did want everything to be passed to Mrs. Jones on his death?
Yes, the short answer is yes. They could change their matrimonial property regime. They would need to go and visit a notaire.
Mm-hmm.
And they could put this clause into that regime, which states that the survivor of them receives everything.
Mm-hmm.
However, works really well when you have children just from the union, no stepchildren involved.
Yeah.
But in this case, there is a stepchild. So that stepchild would need to agree to the change of regime. And when their father, Mr. Jones, dies, they'll have to confirm their agreement again.
Okay.
So it can work, but only if the stepchild
Agree.
agrees.
And I
Yeah.
suppose if they were to go down that route and everything were to go to Mrs. Jones, then on second death, if Mrs. Jones then chose to leave the estate to the 3 children, then the stepchild would have that smaller allowance that you spoke about and the higher rate of tax. So again, it might not necessarily be the best route to do that.
Yeah, exactly. I mean, Mrs. Jones at that stage could have several options open to her. She could look to move back to the UK. It may be that she doesn't want to stay in France now
Mhm.
she's been widowed. And if
Yeah.
she brought her assets back into the UK, then the tax difference between stepchildren and children falls away. So it
Yeah.
becomes irrelevant. She could look at an insurance fee, a life insurance
Yeah, I was going
policy
to
in
say,
France.
yeah, of course, there are certain structures, vehicles that can be utilized in France in order to minimize tax and have more control. So, yeah, there are certainly lots to think about there. I think all really comes down to what their wishes are in terms of who should have what and when, basically.
Yeah, absolutely.
Okay, good. Thank you. So let's move on and talk about Switzerland now. So if we look at a case study between the UK and Switzerland, we've got Mr. and Mrs. Best. They're both 60, Swiss resident, British nationals, and they are considering whether they want to stay in the UK or no, stay in Switzerland or return to the UK for their retirement and what may be best for their family. They have a Swiss pension worth about 1 million Swiss francs. They've got a UK pension worth 1 million, cash and investments, property in Switzerland and property in the UK. So yes, factors to consider here. Can they leave their assets to whoever they like? And what tax consequences may there be in the event of their death, either in Switzerland or in the UK? So Charlotte, do you want to go through this and touch on the differences between the both jurisdictions?
Yeah, so firstly, I should say when clients ask whether it's best to return to the UK or stay where they are, it's important to look at it in the round. So what do they want to achieve ultimately? If, they're down in sunny Spain and they're very much enjoying the weather, I would be very hesitant to recommend they move back to the UK just to save some tax. However,
Sure.
if tax planning is your absolute passion, you would like to save every penny of tax, or it is just
A
part
factor.
it's yes, a factor, a part of the puzzle that you want to look at, then look away or look here even. So if you remain in Switzerland, um, firstly, I should mention that the UK property is always going to be taxable in the UK. HMRC love to tax property on its soil, so that it's always going to be assessed for UK tax. But there are UK tax allowances. Each person has a nil rate band, a tax allowance of £325,000 per person on death. So the house in the UK is worth 500,000. So between the two of them, Mr. and Mrs. Best have a tax allowance that could cover all of that. I should mention that tax allowance is transferable between spouses. So if Mr. Best left everything to Mrs. Best, on her death, she could use, or her estate could use, her 325,000 and her husband's, a total of 650,000. If they are resident in Switzerland, then the Swiss are likely to assess their worldwide assets for Swiss inheritance tax. It's quite difficult for me to give you an exact percentage because each canton in Switzerland is different. Some cantons have no inheritance tax, some do. Some have very generous allowances for spouses and children. So where you are in Switzerland will be very important to this particular exercise when ascertaining what the tax liability will likely be. If there is tax payable in the UK and in Switzerland, the double taxation convention is going to be quite helpful. It will determine which country can tax which asset and also how any tax paid twice can be credited. So your family shouldn't have to pay tax twice. Now, forced heirship. There is forced heirship in Switzerland. Broadly speaking, quarter goes to the spouse, quarter to the children. The other half you can leave under the terms of your will. So you have a bit of flexibility there, but not loads. If you don't want to follow Swiss forced heirship and you are a resident of Switzerland, you can rely on Swiss law, which in a similar way to the European succession regulation allows you to choose the law of your nationality to apply. So even though Switzerland is not in the EU, there is a very similar law. So you can choose for English law, English testamentary freedom to apply in Switzerland. So Mr. and Mrs. Best, lots of freedom there if they like.
So they obviously would need to stipulate that by means of writing a will in terms of which law they want to be applied, yeah.
Yes, yeah, it wouldn't be applied automatically. They would need to take an active step to benefit from that.
Yeah.
Now at the bottom, we've got cash and investments and pension with a question mark. So the reason the cash and investments have a question mark, you may have noticed up above, we haven't said what country they're in. Dependent upon the country in which those assets are located will be dependent on how they're taxed. So if you have a lot of money sitting in the UK, the starting position is HMRC will want to tax that, even if you are in Switzerland and under the terms of the double taxation treaties, you're considered Swiss resident, Swiss domiciled. So if you're living in a canton where there is no inheritance tax payable, you might want to consider moving your movable assets in the UK, your cash investments, over to Switzerland. If you're very worried about inheritance tax, it might be a better place for those assets to be situated. And finally, UK pensions. The reason that's got a question mark is that the taxation of pensions is quite complicated. And again, it will depend on the type of pension you have and the canton as to whether that will be taxed. So if you have got a very large pension pot, it would be worth getting specialist professional advice from a local advisor.
Okay.
Okay, and so the other side of the coin, should they move back to the UK? So if they move back to the UK, they then have testamentary freedom in the UK, but they won't be able to elect British law to apply in Switzerland anymore because they won't be Swiss resident. So their Swiss home, if they still own it, will pass under Swiss forced heirship. So bizarrely, by moving back to the UK, they've actually given themselves a little less freedom for their estate planning. Being in the UK, HMRC will want to assess their worldwide estate for inheritance tax. But again, they've got the £325,000 each that they can leave, together, that they can leave tax-free. There is also an additional tax-free allowance in England called the Residence Nil Rate Band, or the RNRB. It applies if you leave a home to a direct descendant. and it can bump your 650,000 tax-free up to 1 million. In this particular case, though, Mr. and Mrs. Best are a little too wealthy. If you have assets in excess of £2 million, then the allowance starts to taper. So if they go on a spending spree and reduce their level of wealth, then their estate will be able to benefit from it. Tax in the UK is assets in the UK are taxed at a flat rate of 40% over and above the nil rate band, the tax-free allowance. It's important to mention here again that your pension won't be included. Your UK pension will not be included for inheritance tax calculations. However, if you have a non-UK pension, it may well be. Again, pensions are all quite different, but many overseas pensions that work very well in the jurisdiction in which they were set up don't work so well for UK inheritance tax. So again, that's something to look into and take advice on. And finally, I've talked about the double taxation convention a little bit again. So if the property is in a canton in Switzerland that does apply inheritance tax, and your family does pay tax in Switzerland, that can be offset against the tax applied on that asset in the UK.
Yeah, that's really useful to compare the two. And obviously both jurisdictions work in very different ways. And again, I suppose it touches on what I talked about at the beginning of the presentation. It's thinking about, yes, the rules and regulations, but also how they apply depend upon the type of asset and where that asset is based. And as you touch on, even within the country itself, if you think about Switzerland with the different cantons, the different taxation rules that apply across the different cantons, and it may depend on the type of pension, as you mentioned as well. So it can be a bit of a minefield. So yes, I would urge anyone who is considering, whether it's Switzerland, UK, Spain, France, wherever you are planning to retire, if you're thinking about, if you're sort of on the fence between two countries, then I would be encouraging you to look at it this way and consider some of these rules and ensure that you do obviously speak to someone who can look under the bonnet and look at what is particular for you and your situation. Okay, so we have the final topic of gifting now, and whether or not it is a good idea. So from a financial planning perspective, I think first and foremost, before the idea of gifting is entertained, it's vital that you ensure that your needs are met first of all. The last thing you want to do is to gift all of your assets away and run out of money. So yes, that's again why it's important to have a very clear plan in place to identify, okay, what is your expenditure going to look like? Do you have sufficient funds to last you at and through retirement? And if you get to a point from and identifying that there is excess cash available, and that excess cash, having gone through calculations and so on, may then be exposed to inheritance tax in the future, then I would suggest it may be a sensible idea to consider gifting. And again, it can vary from place to place, depend upon different allowances and taxes that should be considered. So in the UK, again, Charlotte, you touched on this before, you can give, from an inheritance tax perspective, we can choose who we want to give it to. From when it comes to gifting, you can give away any amount free of inheritance tax. However, you must survive for a period of 7 years without that gift forming part of your estate. And as I touched on, it can be a very good way of reducing your estate's inheritance tax bill, obviously, if you can afford to do so. Charlotte, do you want to just touch on how this may work in other countries and just maybe talk about some of the things to look out for if overseas British nationals are considering gifting, maybe across Europe?
Yeah, so in most European countries, there is not only inheritance tax on death, but there is also a gift tax. So we spoke about France, for example, earlier, saying that on death there's 100,000 euros that each child can receive tax-free from their parent. However, it's a little more complicated than that, and actually it applies to life as well. So if a parent gave a gift of 200,000 euros to their child in France, then the first 100,000 would pass free of tax, but the balance would be taxed at the child rate, 5 to 45%, depending on how much they receive.
Mhm.
And then if the parent died within 15 years, they've actually used up that 100,000 euro. In France, it's a 15-year sort of bounce back to the full amount.
Mhm.
There are different types of taxes, as Carla said, in the different countries. Switzerland, as we spoke about earlier, different cantons. Each canton will have a slightly different view on gifting with a different tax rate.
Mm.
Now, this last point is interesting because depending on the country, where the gift is being made, where the donor, the person making the gift, lives, and where the donee, the person who is receiving the gift, lives, there can be different tax. So you could have a case where you have to pay the tax if you are receiving the gift. So most European countries, that's the case. But you might be coming from a country where actually it is the person who gives the gift that pays the tax. There can be some unilateral or double taxation reliefs available, but if you are gifting assets internationally, it's really important to look at where you're based, where the person who's receiving the gift is based, and where the asset being gifted is based. Because in a worst case scenario, you could end up with several different sets of taxation on the same gift.
Yeah, and I think that leads quite nicely onto the case study we have on this, where we're here providing an example of a couple, both resident in the UK. They've got a daughter, Sarah, who's resident in France. They would like to give her a French property worth 500,000. And yeah, Charlotte, if you want to maybe talk through some of the considerations that they should be just thinking about if they were to go ahead and gift this property to their daughter in France.
Yeah, so Mr. and Mrs. White, they're both UK resident, and they're also UK domiciled for the basis of this case study.
Mhm.
Domicile is important for inheritance tax, and residence is important for capital gains tax. So if they make a gift, they need to think about both their CGT position, their capital gains tax position, and their inheritance tax position. Sarah's resident in France. In France, beneficiaries pay tax on gifts that they receive. So Sarah will need to think about what she receives. And we need to think about their age as well. So in order for Mr. and Mrs. White to give away their property inheritance tax free in the UK, they need to survive it by 7 years. Are they both healthy at 75? If they're in good health, hopefully they'll live another 7 years. But if they're not, they may want to think quite carefully before making the gift because they may have to pay capital gains tax. So in the UK, when you give away a property, it's called a deemed disposal. And if that property has gone up in value since the time you acquired it to the time that you gave it away, you pay capital gains tax on the gain. So
Even if the property's in France.
even if the property is in France, yeah. So you may end up with a situation where there's no capital gains tax to pay in France, because in France, they're a little more generous in some ways. After you've owned a property for a long time, you no longer have to pay capital gains tax. But in the UK, we don't provide that allowance.
Mm-hmm.
So in a worst case scenario, Mr. and Mrs. White might give away their property that they bought for, 10,000 euros back in 1990, and it's now worth 500,000. That would be quite a big gain, but say it was.
Yeah.
They would pay a substantial amount of capital gains tax. And if they died within 7 years, there'd also be inheritance tax due.
Yeah.
So they need to be quite careful about that.
And that's really important for anyone who's currently resident in France that owns property and if they're thinking about selling the property, then it's obviously then better to do so whilst they're still French resident, as opposed to wait until they're back in the UK.
Yeah, I mean, we do allow, or we give an allowance for your primary residence. So if it is your home that you're selling, you get a capital gains tax relief for that, which is great. But if we're talking about a holiday home, then there is no similar relief there.
Sure. Okay.
So Sarah is living in France. She's been in France for quite a long time, which means that she has to declare the gift when she receives it. The notaire will insist upon that, it's property. And so she can get the first €100,000 tax-free, but she will have to pay tax on the balance. So the 400,000 will be taxable.
Okay. Yeah.
So approximately about 78,000 in this case. An alternative to gifting a property is gifting cash. In the UK, it's quite good to gift cash because there's no capital gains tax payable on cash, so that's useful. If Sarah has only recently moved to France, it's a good time to give her things if you're in the UK. And that is because of a rule that says that you have to, sorry, can I redo that bit?
Yep.
Alternatively, Mr. and Mrs. White can give Sarah cash if she's only been in the UK. Sorry, third time. Alternatively, Mr. and Mrs. White can look to give away cash. The benefit of giving cash is that it is not taxable for CGT. So that can be a more tax efficient asset to give away than a property if you own a property that has a large gain. And alternatively, if Sarah has only been in France for fewer than 6 years, there'll be no French gift tax for her to pay. So the timing of the gift can be important. So if Sarah has been in France for, 3, 4, 5 years, this is the time to give her assets because she won't be paying inheritance tax on a British asset, on cash given to her.
Okay.
And finally, I've said here, be cautious of French gifting techniques. It's very common in France, and it's a really tax efficient way to give property to dismember the ownership of the property into the life interest, the right to enjoy the property, and the underlying ownership, the bare ownership underneath. So it's very common for a parent to dismember their property into two. The parent remains the ability to live in the house to enjoy the rent, but on their death, the child automatically becomes the whole owner of the property. When the parent dismembers the property, there's less tax to pay than if they had left it until their death, and then it passed to the children. Great in France. Doesn't work very well if you're UK tax resident. There are CGT and inheritance tax issues in the UK. So do be cautious of using a foreign tax saving technique whilst UK resident.
Sure. Okay, fantastic. I think this really stresses the importance of, I suppose, being British. We may have a British mindset of understanding the 7-year rule and so on. But just to tread carefully if you're overseas or dealing with assets overseas, beneficiaries overseas, and so on, to be taking into consideration, obviously, some of the rules, regulations, nuances in all of the applicable jurisdictions. So I'll just, oh yeah, there was another just final point. There is a small allowance, isn't there, for grandchildren? So that could potentially be something that they may want to take advantage of as well. So I'll just provide a summary now. So first of all, the first step is to make a financial plan from an estate planning perspective. Ensure that you have a will in place. Make sure that you have nominated beneficiaries on your pensions and these are up to date. Consider trusts or other types of tax efficient structures like assurance fees in France where appropriate. Use gift allowances and check that your marriage regime is actually in line with your wishes. if you are living in a country where there are marriage regimes. And finally, if you are wanting to put a plan in place, or make a gift, or make any changes, then I would urge you to speak to professionals, just to make sure that you're going about it in the right way, as we've seen from the last example there. By taking action without understanding these rules, it could end up costing you a lot more from a taxation perspective. So I'd like to thank you all for joining today. And thank you, Charlotte, for all of your words of wisdom and advice. If you'd like to reach out to either one of us, you can find us using with the contact details here. Are there any further points that you'd like to make, Charlotte?
No, it's quite a complicated subject to try and speak about in approximately an hour, but I hope everybody's found that useful. And yeah, please don't hesitate to get in touch if you have any points that you would like to be elaborated upon.
Thank you then, Charlotte.
So
Okay.
thank you, Carla.